Shifting focus, big day in the Supreme Court. Three big cases lined up for the day. First, the Citizenship Amendment Act, in which the centre had filed an affidavit. Second, the Places of Worship Act. And thirdly, the Sedition Law, in which Supreme Court will resume hearing. The Citizenship Amendment Act has been under the scanner since its inception. After a gap of over 2 years, the Supreme Court will resume hearing petitions challenging the constitutional validity of the CAA. The centre has strongly defended and justified the act in its affidavit, saying that the government needs to save its citizens from persecution in foreign countries. However, the petitioners argue that any classification based on religious identity violates the fundamental rights provided in the Indian Constitution. We have Harish live with us. Harish, big day in Supreme Court today. Of course, as far as CAA is concerned, centre has filed an affidavit saying CAA is a benign piece of legislation. It has defended and justified CAA and says it does not affect existing rights of citizens. Take us through what is going to be expected in the court today as far as the entire CAA hearing goes.
Yes, Radhika, good morning. As you rightly said, a big day in Supreme Court, especially as far as the controversy over the Citizenship Amendment Act is concerned. The Supreme Court has taken the matter out of the cold storage, and today's hearing will be resuming after 2.5 years. And there are around 231 petitions pending before the Supreme Court. Prominent among the petitioners are the Congress party through Jairam Ramesh. There is Asaduddin Owaisi's petition, DMK, Kamal Hassan's party, Mahua Moitra, and several parties from the Assam, especially prominent among them the All India Assam Students Union, who argue that the CAA is discriminatory, unconstitutional, arbitrary insofar as it singles out Muslims from granting citizenship and only grants the citizenship to Hindus, Sikhs, Buddhists, Christians, Jains and Parsis, and therefore this is discrimination because even the Shias and Ahmadiyya Muslims are also facing in fact persecution in these countries, and question why these section of Muslims are also not included. And they also say, as you rightly said, that granting of citizenship on the basis of religion is against the secular character of the country, and citizenship, the only criteria for giving citizenship should be birth and descent. But the centre has staunchly defended the CAA through an affidavit filed late last night. It has said that the centre is competent to draft rules as far as the citizenship is concerned, because citizenship falls in the union list, not state list or the concurrent list, and Parliament is competent to draft rules and the sovereign power to draft rules regarding the citizenship and foreign policy, and therefore the court should stay away because only Parliament and the centre has the power in matters of policy. As far as citizenship and foreign policy is concerned, the court should not interfere, and therefore the centre says all these 231 PILs should be dismissed on this very ground. The centre also says that as per the doctrine of reasonable classification, it exempts the government from applying the same law for everybody in certain situations, and this is a peculiar situation where we have to save the non-Muslim minorities in Pakistan, Afghanistan and Bangladesh, and whoever had come to India before the cutoff date of December 31, 2014 can apply for citizenship, and therefore, and also very significantly says that the democratic, secular and legal rights of the present citizens of this country are not violated in any manner. This is a very significant statement, and says that so there is also it says that all the controversies are misplaced and misleading, and these PILs are misleading the country. and also says that the Supreme Court should dismiss these petitions. And on another ground, one more ground cited is that several successive governments before 2014 had in fact attended to these problems faced by the by these non-Muslim minorities in these countries, but have not brought out any legislation to protect them. So these are some of the main grounds, and apart from that, the government also says that these persecuted class forms a separate class of citizens for whom a separate law can be legislated by the parliament. So today we'll have to wait and watch what kind of order the Supreme Court will pass after going through the centre's affidavit.
Certainly. So centre, of course, defending and justifying the Citizenship Act through its affidavit. Harish, stay on with us. In fact, Supreme Court will resume hearing batch of petitions seeking scrapping of the contentious sedition law. Earlier, the Supreme Court had stayed all proceedings in pending sedition cases and directed the centre and states to not register any fresh FIR. This is the first time in 162 years that the operation of the colonial era penal law has been suspended. Let's go back to Harish. Harish, another contentious law has been sedition law. Take us through what had happened in the past, because we know for a fact that Supreme Court had stayed all proceedings in it and had asked states not to register any FIR. So what is expected as far as the entire sedition law matter in top court is concerned?
Yes, that's right, Radhika. It's another very crucial, important issue. And remember, in February, the then Chief Justice bench, led by Justice N.V. Ramana, had questioned whether the centre wished to retain this colonial archaic law, which was once used to, in fact, stifle, deal with the protest during the freedom movement led by Mahatma Gandhi and Bal Gangadhar Tilak, and which is used to stifle dissent and crack down on freedom of speech and expression. So after several strong remarks, the centre had on May 11th filed a very important affidavit in which it said that the Supreme Court should stay away from adjudicating this matter because this is the domain of the public policy, and government itself is planning to re-examine this sedition law, and this matter should be, re-examination of sedition law should be left to the government rather than Supreme Court. And even the Prime Minister, on the 75th year of independence, while the country is celebrating Azadi Ka Amrit Mahotsav, it plans to shed the colonial baggage of several archaic laws, and law could be one of them, and Supreme Court accepted the argument and request of the centre and had deferred the adjudicating on the matter. But at the same time, very significantly, as you rightly said, the Supreme Court had in fact directed the centre and states not to file any fresh FIRs pertaining to sedition, and also stayed all the pending proceedings, and had given the liberty to all those accused in sedition cases to approach court for bail. So this was a very significant direction, and after that, today is the day when the matter is coming up next. The centre is expected to brief the court as far as what steps they have taken to, as far as re-examining the sedition law is concerned, whether they plan to scrap the sedition law.
Right, Harish. So sedition law under scanner after what is being called as its rampant misuse. So big day in Supreme Court. We'll keep coming back to Harish for more details on what exactly happens once these matters are heard. In fact, in the Places of Worship Act, the centre is expected to file affidavit today. The hearing is scheduled to take place on 14th November. This is even 1 year and 7 months after directed by the Supreme Court. Centre has not filed an affidavit in the court. The Supreme Court had, in fact, issued several notices to the centre seeking its stand. In the Places of Worship Act, in fact, the centre is expected to file its affidavit today. Hearing is scheduled to take place. In fact, this is even after 1 year and 7 months after directed by the Supreme Court. Centre had in fact not filed an affidavit in the court. In fact, Supreme Court had issued several notices to the centre seeking its stand.